Estamos de volta para o último painel agora do evento. Enfim, hoje a gente vai... Esse último painel, muito embora ele tenha ficado por último, com certeza é um dos que eu estou mais aqui ansioso para ouvir, que vai tratar aí de lições aprendidas, ou seja, questões bem práticas aí de como a gente evitar aí custos adicionais e atrasos em obras. Então, acho que não poderia terminar melhor o evento do que com esse painel. E eu vou passar, então, a palavra para a Adriana, que vai ser a Braghetta, que vai ser a moderadora desse painel, e desejo a vocês aí um ótimo painel e agradeço novamente a todos. Thank you, Laura. Thank you, Marcela and Shona, for being a part of this event. And I'm looking forward to hear you. Thank you.
Okay, thank you, Victor, very much. I'm honored with the invitation to moderate this incredible female experts. And I think, first of all, thank you for choosing a panel of only women in construction arbitration. It says something. It says that the world is changing a little bit. We are empowering women in a certain way. Thank you, Victor, for that. So, dear friends, we have a very distinguished panel members. I'm going to introduce them to you. First of all, one sec. First of all, Shona Frame is a partner in the infrastructure and construction disputes team at the international law firm CMS. As you know, CMS has more than 5,000 lawyers. It's spread all around the globe. She has more than 25 years experience of providing strategic advice on management and resolution of disputes as arbitrator, as an adjudicator. Laura, on the other hand, Laura has more than 17 years as a consultant in FTI. So she will help us to know the state of the art of all the problems she's facing throughout the execution of the agreement and afterwards. And then to complete our panel, Dr. Marcela Radovic, an arbitrator, very experienced, more than 20 years sitting in construction cases in Chile. So girls, as you may see, we have almost 90 participants. It shows how developed the construction arbitration market in Brazil is. And let's try to give to them what you have told me through the prep calls. For the information of you all the participants, what we have decided actually was Shona's suggestions that we go through the issue of delays and additional costs through the stages of the construction, the very beginning, the execution phase, and then the dispute resolution. Obviously, when we think about phase 2, the execution of the process, the execution of the construction, sometimes, and you will see, it has to do what was told in the previous panel, sometimes to start methods of dispute resolutions may be very convenient, may be very efficient. So I will start with Shona. Shona, tell us what you think about associations, how to minimize, mitigate delays and additional costs in this early stage when people are negotiating an agreement, when people are preparing for execution, please.
Thank you. Yeah, so I guess to set the scene, I suppose, with the problems that we're all aware of in the stage of establishing a project, we're all aware there can sometimes be a rush to award the contract to get started on site, and sometimes before the project concept is fully developed and before the design is fully prepared. Also before it's been planned properly in terms of how to deliver the project. There can sometimes be a lack of clarity about what the aims of the project are. There can be unrealistic budget expectations about what the project should cost. And that's sometimes accompanied by a short-term view, focusing on the capital cost of the build, not the whole life cost of the building or the infrastructure. And so there can sometimes be a race to the bottom on price, and the cheapest price wins often. So we were asked as a panel to look at how do we address these sorts of problems. And as I see it, in this establishment of the project phase, there's probably 3 areas. One is upfront planning. One is the contract itself and setting that up properly. And the third is a sort of softer but very important one in terms of setting the tone for the project. And if there's time, Adriana, I'll just briefly touch on the 3, and then I'll let others comment.
Please go ahead.
So in terms of the upfront planning, the sort of gold standard and what we would suggest as ways to mitigate the problems that I outlined are investing in upfront planning to ensure that the project is both deliverable and affordable. And that involves setting out a clear specification for the work that's to be carried out, so that everyone is clear from the beginning what is to be delivered. That can be helped with early engagement with stakeholders, including end users, but also the supply chain, to discuss the project. What do the end users want to see? What's the best way to deliver it? They may input into the design. They may consider issues about constructability and how feasible the design concept is to actually build on the ground. That might involve looking at cost estimates against benchmarks of other similar projects, so that it's clear what a project should cost, and including looking at contingencies for extra costs that might be incurred. And also, and I'm sure Laura will come on to talk about this, looking at the programme or the schedule for the works. What's a realistic assessment of how long the project should take to build? But also things like, when does it make sense to start? It doesn't maybe make sense. I'm in Scotland, so it maybe doesn't make sense to start your groundworks in the winter or when it's particularly rainy. Maybe it makes sense to start in the summer months, and you'll get a better run at the project. So just considering what's the best timing to start. On the second point around the contract, and again, I'm sure everyone will have comments on this, but undertaking an early risk assessment. What are the risks and what mitigations can there be to deal with those, but also who will bear the risk? And remembering that if risk is passed down the supply chain, in the pass the parcel mode of sending the risk to the party lowest down in the chain, everybody will be pricing that risk in. So sometimes an onerous risk transfer actually just increases costs. Also looking at the contract terms around change management, and whether the contracts are being set up in a way which is too one-sided. Maybe too much risk is transferred. Maybe the price and the price changing mechanisms are too onerous for the contractor. Looking at some of the mechanisms for additional time and cost. Some of those are no fault events, so site conditions, weather, and again, considering whether those could be mitigated at planning stage. But some are fault events. So for example, an employer instructing changes or permits not being in place. And again, a lot of that can be mitigated through this early planning of the project so that everyone is clear what's to be built, and it saves late changes, which are where the additional time and cost comes into play. And just to finish on the third topic, setting the tone, communication and behaviours. We discussed this quite a lot when we were preparing for this session, but just setting the tone on how people will deal with each other on the project, being clear on individual accountability and responsibility, and encouraging open conversations, really to try to set it up so that the doors are open to allow discussions when problems do happen, to I guess set it up for resolving issues rather than immediately going into silos and triggering disputes. Okay. And my final point is just getting the right team in place, the right team for the job, a contractor of the right size for the type of project, the right supply chain with experience. Yeah, so hopefully those three areas kick off a bit of a discussion. So I'll stop at that.
The ideal world, it will be great if we have that scenario. So, so please, Marcela, what do you think? What could you add in this phase of the project in which people are planning? What generally gets wrong? What's your advice?
Well, I cannot agree more with what Shona said. I think it's a very complete scan, you know, in this first phase. And I will just add something that is maybe related with the diagnosis. I think it's very important in order to be able and to be effective to mitigate, to be aware about the scenario we are doing things today. We discussed this also in this team. And we agreed that the time it's very, very complex. Construction has always been very complex and intricate, but today probably it's like very difficult to plan something and then to be there living what we planned before. So when you speak about scheduling, for example, and planning, the most probable thing that's going to happen is that your schedule is not going to be there after even 1 week. Because things are happening and we cannot really control things being very uncertain. So having said that, I think we need to add something else. And I think that element is flexibility, capacity of being able to adapt. So if we say that, we obviously the question we will have is, how do we adapt together? Because this is not just the contractor being able to adapt, it's also the owner. But on top of that, complexity demand from us to be able to collaborate in order to adapt to uncertainty. So that is something that we never done in projects. I think in all my 20 years of experience, I just had, I think, 2 or 3 projects where I've seen people collaborating. But this is because they were very good leaders and they had amazing skills, communicational skills, leadership, vision, even being humble, which is a very rare factor in construction projects. So I think I'm not saying we need to have this kind of contract or contract framework or this other one. I just said collaboration is something that we need urgently. And we can find collaboration in different spaces in construction, but it's important that we approach and we try to achieve that in the contract, I mean, the contractual framework, but also the tools we use, but also, as Shona said, the right people to embrace collaboration. So, and technology. So we need to be aware that collaboration is really a change of mindset, a complete transformation of the construction industry. I mean, you can use all the expert tips, but you can, even using that, you can fail. So the question is, what else can we do? And I think we really, really need to, to think and to at least try in some specific projects to do things differently and then compare. Because it's obvious we're not going to have numbers. Because people say, yeah, okay, you want me to change. Show me some tough, you know, some real figures. I want to see this in figures, in productivity. And I said to them, unfortunately, we still don't have enough critic mass to prove this to you. But a question I always make to people, to leaders, to clients, it says, are you getting what you want in construction projects today? Having great experts and lots of mechanisms. And they say, no, we're failing, even owners. So even, I think the worst scenario is always governments, which is even worse because they need to satisfy some social needs, very important needs. Even in Latin America, it's even worse. So if we are not achieving what we want, doing things how we've been doing them forever, so I think it's very obvious we need to try a different way of approach things. And I think collaboration will allow us to be more flexible, to be resilient to things that happen as the way we never plan, but it's a combination. So planning, records, you know, the typical very important things, coordination, planification, it's great. So we have control here, but we also need some flexibility, resilience, and collaboration. It's a combination. And I think with that recipe, at least in my experience, it works better.
Okay, I think before I open the floor to Laura, I think one of the issues that Shona mentioned, it's accurate. It's the problem of the cheapest price. You know, the owner is creating additional cost at the very late stage of the procedure. So, and you've pointed out all those issues. You don't have sometimes a good team. You just want to sell the project. So you do whatever, you reduce your margins to sell the project. You do some have contingency risks, but they are unclear to the owner in where you're going to use it. And so it's an unclear scenario in which the owner at this early stage want to pay less. It's not seeing all the risks, and sometimes not prepared with poor quality projects, and the constructor is hoping that he will try to solve the future problems throughout the execution. So Laura, please tell us, and please also comment on this additional problem that Marcela posed, which is when we are dealing with governments. And I would add another additional issue that I want also Shona and Marcela to comment. I've noticed that the owner also sometimes is government. And nowadays we have seen lots of funds as owners, and they are extremely delicate to negotiate. So when we are in this stage of planning, how can we deal with this new world?
Sure.
Please.
Yeah. Thank you for having me as well. I think a lot of great things have been said by Shona and Marcela and yourself, and there's a few areas that I want to tag in on, just to reiterate or kind of expand upon my background. I work as an expert quantifying the schedule delays and loss of productivity and damages and things once things get to typically a dispute phase. We are involved in projects during the execution, but that leads me to have a particular perspective on most projects with, you know, the highlight reel, if you will, of how things have gone wrong on other projects. And so I'm really bringing that perspective. I mean, we're not typically involved at the very front end of projects, but I see how certainly things that have gone wrong at the front end have led to very expensive problems to resolve later. And so I'd like to echo, perhaps to your point and Shona's point on, you know, the drive to the cheapest price, maybe aligned with that is really the risk that is created in that early planning phase when the initial schedule for the project is set. And I think that, you know, the drivers for that schedule can be, you know, your financing for the project, it can be market conditions. And when we see very aggressive schedules set without a lot of thought to what is the related construction effort that will be involved, and it's really just getting your contractor on board after, you know, the owner has already decided what the timeline for this project is. And I think that that's where I think of Marcela's comments on flexibility, because there may be, I mean, certainly you have to set a timeline when you're going out to, you know, seek, you know, the start of this project. But then as things happen, as you start to get further information and input from your contractors or your bidders, you know, to understand that maybe there needs to be some flexibility in that schedule, or that initial thought on how aggressive the schedule will be. Or there's certainly been projects that I've been involved in where the feed process ended up having a problem with it. It's certainly very early stage, and everybody on the project is looking at that going, we can make it up in construction. And so it's maybe an aggressive schedule where it's already been decided that you're going to overlap engineering and construction, but then the very early stages of engineering are also delayed, and that creates even more of an overlap. That risk is increasing exponentially. I mean, making it up in construction is extremely expensive. And so I think all parties involved on construction projects can do themselves a favor in mitigating risk with a bit of an eye open to, you know, constantly asking and revisiting, you know, is our schedule expectation reasonable? And, you know, that takes both sides recognizing that and working together to set something that's appropriate. And I just wanted to share one example, you know, in this vein. One of the projects that I worked on a few years back was an aggressive schedule feed delay. And I remember going through the documents and recognizing that early in the project, as they were setting their baseline schedule, they ran a Monte Carlo analysis to test the risk and achievability of the schedule. And that spits out, you know, when you're done with that process, it gives you, here's the probability of your schedule, and it's reported in a P value. P90 is a 90% chance that your project is going to fall within that schedule duration. And I found in the records, you know, executive meetings, and they're setting the schedule, and it's a P10 schedule, which means that it's a 10% probability that they're going to achieve the project within that duration. And that was the schedule set. And you move forward. They never changed the schedule. They agreed. We've got a 10% probability of success here. And they ended up in, you know, serious dispute over project delay, when frankly, there was a 90% chance that you were going to miss the delay or miss your target substantial completion date. And so whose fault is that? And now they're arguing over who has to take responsibility for that. They already knew, you know, they should have known. And it just goes to, you know, digging into the behavior at the early stages of recognizing how that can snowball. So that's some thoughts on upfront planning from myself. I will say, Shona mentioned just the contract terms, focusing on setting up your contract terms with respect to change management. And again, I'll reiterate, you know, I'm certainly not sitting in the rooms when contract terms are being negotiated, but I am, you know, sitting in the rooms when we're dealing with contract terms that didn't play out the way that they were supposed to. And so I do think that there's a little bit of a disconnect at times within organizations to make sure that that perspective is being fed back to the right teams, where your teams or your outside counsel that is dealing with, you know, unhelpful contract terms as they've eventually played out, you know, are they communicating with and feeding back to your legal teams that are at the front end and doing the initial negotiations of contracts? And that's, I think, something that I know from speaking with other attorneys to be done better at different organizations. So that's a point there as far as what can you do in the front end, is kind of seek that input. And I do think that there's a very real issue with continuing to work as an industry to be more collaborative and partnering, you know, and you hear those terms often and you see it done well and you see it done not so well. And I think, you know, in some of the other arenas that I've seen contractors and owners really develop a great relationship, those are the projects where they have the opportunity to try the groundbreaking and new things. But it does take both sides of that relationship to be willing. You know, are we going to try this new technology that helps us with, you know, productivity on the project site? It's completely brand new, but you need to have that trust and relationship between the contractor and the owner in that situation, that's something that they want to be a part of. And so you are seeing signs of that, and you see it in certain circumstances with certain organizations, that they are better at that collaboration. And it's an eye towards really future planning for the construction industry and being in it for the long haul. I do think there are many, many claim situations that I've been involved in where there is a government client. And what I see there is typically there's an inability, or just you know, the way that the government operates is that the individuals overseeing the project on behalf of, you know, the authority or whichever faction of the government is you know, procuring the project, they're not necessarily given the flexibility to be collaborative and work with their contractor, where it's not private funds, it's public funds. And so there's a different level of responsibility that they need to be, you know, cognizant of as they are discussing, you know, the inevitable things that change on a project and drive costs up. So where I see that, it ultimately ends up being that when you've got a direct client in the government, I see that very often there is a drive to reduce the risk to the authority in the present tense. You know, when claims occur, they are very risk averse, and they're not agreeing to move schedules, and they're not agreeing to change orders and things that, you know, are very real happenstances on the project. And so it's a short-sighted view of the risk there, because if it's too owner-focused risk mitigation and not project-focused risk mitigation, and if it's too much, I don't want to pay this cost right now, you know, that is kind of the perfect storm for major litigation on the back end of the project. And so maybe just having, you know, if you have an avenue to speak with others about that, that's a concept of taking the longer term view of really what risk are you mitigating. And it serves everybody to mitigate the risk on the full project versus just for your organization.
Thank you, Laura. I would add from lawyers and arbitrators' perspective the following: this phase, negotiation phase and planning, is crucial when we will be there deciding the case. So obviously, transparency towards the client, if you are defending owner, for the defending constructor, to say, you know, I haven't allocated this risk to myself, so the delay occurred for this issue. And what I mean by transparency, if you are transparent, you are very clear in your proposal. And if you are able to show that in a future disputes, you will have another level of degree of success. I'm always thinking about the disputes. You guys, you're thinking about the whole process. But I'm listening to you. I'm remembering a case in which there was delay. There was also a geological major problem, and there was no contingency for geological problems. But I was able to bring the negotiator that was in the table to the arbitral tribunal to explain that it was very clear to everybody that the risk was not allocated to the constructor. So again, it's planning, but it's you know, you need to preserve all this information, including emails, including drafts of provisions for a future arbitration. Shona and Marcela, anything on the asset funds being the owner? Have you noticed a difference in this market? And Shona, perhaps you can add also, because you have not commented on government as the owner of the building.
Yes, sure. I was listening to both Marcela and Laura, and there's, I guess, two themes that are really important from what they were saying, and it feeds into this government as owner point. Marcela was talking about the need for transforming construction and doing things differently in the future. I think she said, if we keep doing things the way that we've always done them, then the outcomes will stay the same. And collaboration is a real theme that I am seeing coming through. It's being driven in the UK by both the UK government and the Scottish government. The UK government recently published a construction playbook where it set out the way that it wants government contracts to be procured. And it's based on this collaborative working environment, and really trying to take account of the vast amount of infrastructure which UK government, but also governments around the world, have committed to building, and recognising that the only way to build that amount of infrastructure is to do things differently, to properly plan, to speed up the process, but in a properly planned way, and to execute things better, which includes more collaboration and managing and resolving disputes in a much more streamlined way. So it's very early days for the playbook, but it's been mandated for government projects going forward. So government as employer should be, in the UK at least, dealing with contractors on that basis. And it's a detailed document. It's about 90 pages. And it's very much a wish list of how you would want a project to run. We'll see what happens in reality, and it will obviously take some time to bed in. There's a lot of behavioural change required, but it's a really interesting development. You mentioned funds as owners. And I think, you know, funds are there to make money for their stakeholders, their shareholders. And I guess if you make a business case for collaboration, then funds will buy into that. The way I see it is it's much easier to build relationships, to collaborate where there's a pipeline of work, rather than a one-off project with a sort of an SPV, a special purpose company developer. You know, if you've got one project, it's difficult to build a relationship over the long term. But funds are employers who are looking for projects over many years. They're looking to make a return on their investment. And I do think it will be driven by business case, and a business case for better, less dispute construction, I think would be one we could all make. So that was interesting. And my second point is much briefer, but I think Laura mentioned it, and that's to do with lessons learned and understanding what happened on previous projects and applying to future projects what went well and what didn't go so well, and how that might be factored into future projects. And I think that's, again, an important aspect of mitigating risk of both delay and additional cost.
Okay, thank you, Shona. Marcela, anything to add at this point, or we can move to execution phase?
I would just say that I agree with what Shona said about funding. I think there we have a new trend when it comes to projects, but maybe we can just see the experience from international banks, developing banks like World Bank, or the Japanese Bank of Development. Sometimes I know it's like telling these funding groups that the best way to take care of their money is exactly what we're trying to do with changing the mindset. It's difficult because they, as you said, Shona, they just want, it's like a short-term relationship. It's like one time. But I really believe that when you have transparency, as Adriana said, when you have a communication and coherence, you take care of the money. It's just something that not all of these funds really, they are not aware. But I think the worst way of taking care of the money is to be transactional. But unfortunately, I think life is going to show us. It's with the experience. And what you said about the UK government and this playbook, I already read it, and I was like, obviously in theory looks amazing. I'm just waiting for things to happen, and then maybe you can come back to us one day and tell us what happened with that. That's it, Adriana. We can move on.
Okay, so let's move to the execution phase, and the delays started to happen, as they would. So, what is your experience? Tell us, and what can be done to mitigate at this stage? They are happening. Sometimes the owners they want to hide it. Sometimes the contract managers don't tell the owners. They hide them. They hide as well. So. What is the issue? How can we deal with that? Shona, again, with you.
Thank you. Well, I guess you've started to paint the picture there. We're on site, and delays have started. Maybe they're the contractor's fault. Maybe they're under-resourced. Maybe the material supply is poor. Maybe they just weren't ready to start. Maybe it's the employer's fault. The design is being developed on the hoof as the project is progressing. The employer's making up the design as they go along and changing their mind, or maybe the designer just isn't ready yet. And all of these cause additional cost as well as delay. But the other thing that happens, as we all know, is that they cause relationships to start to deteriorate. A blame culture sets in. And then the rush to make up time can lead to quality suffering, and that in turn has its own problems of work having to be redone, defects being rectified, or in fact maybe not being discovered till much later and causing difficulties down the line. Payment issues are one of the key areas where I see disputes arising. Cash flow, obviously, hugely important for contractors, but employers also keen to make sure that cash going out the door is being properly spent. So again, I split the solutions into 3 categories. One was proactive management. The second was change control, which we touched on earlier. And the third, again, this constant theme of communication and relationships. So on the proactive management, just some, I guess, headline topics in that area: operating some sort of an early warning system. Many of the standard form contracts build in an early warning system so that it's clear when issues are starting to happen. In the standard forms, they sometimes work and sometimes don't, but monitoring actual progress against the plan, updating the programs regularly. I know that's something Laura will be interested in. Understanding variances in planned cash flow against actual spend, and identifying when it's going off track, but also why. And having visibility of data about progress and about spend can allow problems to be identified early and then remedial action taken. But taking that remedial action is obviously key to the mitigation that we're looking at here. And I think also the proactive management goes to looking ahead to potential problems which might come up. So looking at the risk register, updating it and working out what are the mitigations, but also what are the actions to be taken if a risk manifests. And then quality management and a right first time culture, so that, and this is quality both by contractors and subcontractors who are doing the work, but perhaps also by the employer, having a clerk of works or somebody on site to monitor quality and address quality issues very early before they become a problem. On the second topic of change control, again, very often in the disputes that I deal with, the cause of delay and additional cost is changes being instructed as the work progresses. So a way of handling that, and again, it's built into some of the standard forms, is a quotation procedure so that you can test the impact of any proposed changes and get a quote of how much delay that change would cause or how much extra cost will be built in if it's then instructed. Obviously that procedure needs to be very efficient so that we don't lose time while we wait for a decision on whether a change is going to be instructed or not, because work doesn't stop while that decision is being taken. But just managing the whole process of change and deciding whether the change is absolutely necessary or not. And then thirdly, the last theme is the communication. And again, that's very often where I see projects derail. I remember reading project files on many dispute jobs, and they all start very optimistic and everybody's delighted to have been awarded the project. And suddenly the claims notices come in and you start seeing the correspondence taking a very different tone. And again, I guess it's managing that communication so that claims letters don't immediately escalate into relationships being damaged. We all know that many of the standard forms require notices when the project's going into delay or causing extra cost. There are time bar clauses associated with getting notices in on time, and despite that, putting in a notice as contractor can be seen as an aggressive stance and being overly contractual. And so there's this real tension between operating the contract and preserving your contractual and legal position and preserving relationships. And I think good lines of communication are absolutely key so that you fulfill the contract requirements, get the notices in, but keep talking about how to manage and resolve the issues as they're arising. And then I think my very final point, and again, Laura mentioned this in her remarks earlier, but realistic performance reporting and challenging reporting that might be overly optimistic. I remember a project, and it's not unusual, where the minutes of meetings were all recording great progress, everything was on track. And yet when I got involved, the project was very much in delay, and the paper trail did not support there having been delays at the periods of time when we knew that they were happening. And so that makes it very difficult to have a discussion about the project having been in delay and why, when the records don't support it. So accurate reporting of progress and of spend, I think is key to the management phase of the contract.
Thank you. And imagine for the arbitrators to decide when all the documents will show that there's no delay problem at a certain point, and all of a sudden, wow. So Laura, what do you think in this execution phase?
I just had to turn myself off of mute. So at the execution phase, I think, I certainly agree with many of the things Shona shared. Having robust project controls that can feed accurate information upstream so that, you're giving your project managers and directors as quickly as possible the information they need to manage the risks and be aware of that. I think that's pretty clear. Also, your effective project controls, I'll echo what I heard on the last panel, is documentation. So we are at times asked to participate alongside project teams during execution. And and it is from an expert's role, what we try to add to that, effort is an understanding of the types of documents and the quality of those documents and what pieces and facts and what information needs to be captured now, such that, as these issues evolve potentially into dispute issues or the subject of claims, that the records exist. Because if you're as an expert, if you're simply joining at the end of the project to go, participate in a litigation, you have what you have to work with from the documents. And if things don't exist, they don't exist. And there's no way to really figure out what happened, in some situations. And you end up using less desirable techniques to analyze that. So I think that is one way that we, have been able to just add some of that risk management perspective into the execution. One other thing that I think is an interesting thing we've participated in is during the execution of the job, and there are productivity issues, and particularly as it relates to productivity. That is data that can be tracked at many different levels of detail. And so if there is an awareness of an issue there, We can work alongside project teams to coach in identifying and documenting a measured mile scenario that is helpful to say, you know, our estimate is achievable. But if you've passed all of the execution of the work and you're looking for a measured mile at the late stage of the project, if you didn't capture the appropriate data at the time, it just, you know, you can't go backwards sometimes on that. So I do think that the project controls and documentation side is very important. As it relates to Adriana at the beginning of the talk on execution, you mentioned schedules, you know, and, you know, hiding of delay or, you know, showing on time completion. And that's something that's very, very, very common. And it sometimes is driven by relationship and contract requirements where the contractor, we've certainly sat across the table from our client and they said, well, we cannot show delay. We cannot, this owner will not accept that schedule. We'll be in so much trouble. We can't give them a schedule that shows delay. But I think that there are some simple tactics that I've seen even required in contracts to try to navigate that. Certainly the contractor has a responsibility to mitigate delay when possible. And they certainly want to be demonstrating that they're fulfilling that obligation. And so really it's just a process for each monthly update that there's an accurate importing of the progress data and updating of the schedule. And simply you capture what that shows. You haven't changed anything in the logic in the schedule. You haven't put in any mitigation efforts. You know, you haven't adjusted anything in the schedule to show on-time completion yet. It's the process of updating the schedule as it is anyway, but it's a matter of simply capturing that snapshot. It's like a progress only schedule. You've captured it down. That documentation exists now to say, this is the progress this month that shows what would have happened had we not then gone forward and mitigated our schedule, incorporated, you know, adjustments to make sure we're showing on time completion. And so that is an option that I've seen, whether those progress only updates are being provided to the owner or they're simply part of the contractor's record for the project. That gives certainly everybody a little bit more to work with and a little bit better picture of what is happening while still aligning with contract requirements that may say that they can't produce a schedule that doesn't show on time completion, which maybe that requirement should be questioned to begin with. But and then I think
before you finished,
yeah.
You mentioned project controls, and when we were preparing this panel, we have discussed this. Primavera is in place for 20 years. So perhaps the market is in need of something better. What do you think? Can you add to your answer?
Yeah, sure. You know, I've got about 20 years in the industry, and when I started, it was Primavera P3, and it was old when I got started as a software. It's certainly recognized in construction as the gold standard. It's required in most contracts to use Primavera. It's just, if you understand the background of Primavera and the software that is actually working in the background there, and you know, I think that there's, you know, some room for, you know, particularly in construction, some room for some recognition that there's a different need on, you know, how the schedule operates and reports out and what the schedule can provide. I do think that there's certainly room for improvement. And Primavera is also a one size fits every industry product. And, you know, we may be, you know, in a position where there's enough, you know, demand for good scheduling software in construction alone to really build software that, you know, leans into what the construction industry needs specifically.
It's a good tip. for program providers that are watching us, please. We need some improvements. And Marcela, what about you?
Well, I think everything that like our panelists, Laura and Shona said, it's very, very accurate because it comes from experience, from real experience. So it's great. It's very precise. And I would just say, I was as an arbitrator and also as a dispute board practitioner, that one thing that we have to bear in mind when it comes to execute a project is that change is part of a project always. There is no project where you're not going to have to face changes. So having said that, as we said that complexity came into projects as well, we need to start from that point. So everything that has to, for me, information obviously it's key. But the problem we have today is that the information we manage is like two separate works. So one party has one information and the other one has different information. And then what Laura said about how do I get my updated schedule approved by the owner? I mean, that's almost impossible when there is no trust, because approving that schedule means for the owner that I am kind of agreeing with that impact that you're portraying in your schedule. So again, we are speaking about trust, transparency. So I think connecting this with the idea of the tools like Primavera, the problem with the tools we have today is that they are neutral. I mean, they're just tools, and they are, obviously, they are very helpful, but they don't drive us to behaviors. You can use Primavera for whatever you want. And if you're not really transparent, you can use Primavera to put everything there, not the reality. So for me, in the future, the ideal scenario for a good execution would be having one source of information. And there is not a source, it's a source of information where we don't build the information, we don't create it, we just feed that source. So the whole project nurture itself from that source that you cannot really manipulate, because as a consequence that in our projects we don't have trust and we don't have transparency because people are in a transactional approach, we create, because we have been saying records forever. This is a very old tip, and still we cannot really achieve it. So because we said that everything is about records, then people create records, but it's their records and they don't really reflect the reality. And also we have a problem of coherence among of them. So you have a report, for example, where it says that you as a contractor being using whatever amount of labor, and then you see another record that the owner created, or maybe even the contractor created that says the opposite, or it shows a different amount of labor. So, when you're an arbitrator and you see these pieces, you say something's not really, there is something weird here. And it's about this what I'm saying, one source of information that it's not that parties cannot really manipulate. While we get there, because I know we don't have it yet, I think dispute board, it's a very good mechanisms to improve execution of like the project execution. I'm not seeing dispute boards now as a tool for dispute resolution. No. I'm just looking at them as a tool for execution, a tool for creating this environment of collaboration we've been commenting, and also assuring that the parties understand the same and put everything on top of the table. And if they don't do that, that they can know that the dispute board is looking at that, and because they are experts, they know that you are hiding, you're manipulating, and you're trying to, create a reality that is not there. So I think if you go to an arbitration without a dispute board, you're going to get these two words, parallel words, where the arbitrator has to call the help from the expert witness, and they need to fill in the gap, the terrible gap that they will find in this, huge quantity of information. And then if you have a dispute board that started from the beginning of the project and there is a proper, proper dispute board with real experts that had all the skills, which are not, there are lots of skills you need to be a good dispute board: leadership, communication, well, all of the skills will be mentioned to do a good execution of the project. Then you will have something similar to one source of information. At least when the dispute board issued the recommendation or the decision, you're going to have a very good piece of coherent information that is going to be very useful for the parties to think about if it's really, really worth it to go to arbitration, or even to the arbitrator to have a more, integrated information of the project. And also, I would like to add that all of the years of experience called my attention that it's very rare, at least in Latin America, to see that the contract defines different kinds of delays. So people in these disputes, they argue about delay. It's your fault. It's your fault, and there are very clear definitions. It's not the same to have an excusable delay, a non-excusable delay, if it's a critical delay, a non-critical delay, if it's concurrent delay or not. And those categories, I don't see them in the contract framework. So I think having a proper dispute board will help also to set some rules or to fill in that gap of, because I don't know, maybe Laura and Shona, even you, Adriana, you can comment about this, because it caught my attention. You see the contracts and you don't see these categories, which are very basic and really, really help the parties to solve these disputes. We're not talking about whose fault. We have to categorize. Is this delay excusable? Okay, it's going to be excusable when the event that really provoked that delay came from somebody who's not the contractor. So if you have the record, you're going to be able to really resolve that. And it's not about who has more power. It's about the rule and following that rule. And then secondly, and this is the last thing I want to say, because I don't want to make our panel to go with a delay, it would be that it caught my attention also that the methodologies that we have to use during the execution of the contract in order to assess the impact of a certain event, then normally they're not even mentioned in the contract. And I know, Laura, you're an expert in this and you can help me to complement, but not all the methodologies are suitable for all kinds of situations. They depend on the kind of information, the kind of event, whatever, but we can set that in the contract. And if we didn't set it at the beginning in the contractual framework, we can even discuss it among the parties and with the dispute board, the standing dispute board, and say, okay, you know what, we're going to use this kind of records. I mean, there is something that the parties never do, and it's to, in the kickoff meeting, speak about certain things that we see after starting the contract, what we also nobody does, nobody do, to set some rules. And that's okay, to create mechanisms, protocols, to agree things among the people who are going to really, really execute the projects, which is normally different people. I mean, it's not the people who draft the contract. So it's good to say, you know what, I studied the contract and it called my attention. There is no definition of excusable delay, non-excusable delay, or the different type of delays. And also, which methodologies are we going to use to measure this for the purpose of the execution? I think all of these things came from my experience, and I'm sure Laura and Shona can say a lot about this.
Yeah, sure. I think it was the three of you, very good points, because it comes to the very end of the situation, which is now we are going to talk about dispute. I will add to some uncertainty as an arbitrator. I would like to see the parties throughout the execution discussing the critical path. Nobody, an expert will say in the future, this was the equitable path on May, but then it changed. Why the parties don't agree on that? It would be awesome. And I enjoyed very much your idea, Marcela, and also Laura, about the parties also negotiating on methodology. Laura mentioned, I have finalized 2 cases as an arbitrator in which we have used measured mile to discuss in productivity. But the major debates on how you can reach the mile, so why don't you give some hints to the arbitral tribunal, or you agree on which will be the general methodology that a future expert may use in a case? Great ideas.
And
great
Adriana,
ideas.
that has to be agreed before the parties start having disputes, because then if you just said that, you tell them to discuss that after they are having the dispute, they will never agree on the method. So it's at the very beginning of the project, when they are still friends.
Yes,
you know?
True. And as we have said during the prep calls, you have delays, but sometimes it's impossible to, the records don't show how to solve that delay or the reflection of the delay. So, and to reconstruct everything 2 years later on, it's almost impossible. So let's move. Please, Laura, please. Yeah, you have all the time.
I just wanted to circle back on what I have seen done very effectively by certain organizations. It echoes Marcela's thought on maybe there's not an agreement on methodology, but there's certainly, when you get to productivity and measuring delay, there are preferred ways to do it. Industry standards that, you know, this is, yeah, exactly. I've seen some organizations are excellent in their change control process in essentially serving up to that industry standard at the very beginning of the change control process. And I've seen that simplify things a lot, because as we talk about relationship management, and when changes and notices begin to, you know, be exchanged, that can sometimes degrade the relationship. And I've seen it where the contractor puts in very transparent data, and it's ticked and tied, it's accurate, and it is the required support that you would need to prove this issue, you know, should they end up in a claim situation. That's a lot easier, I think, and it seems that way from how things have played out, that is a lot easier request for an owner to receive and process, because it is fully supported and aligns with the methodologies that are the preferred methodologies. And I'll just add this one piece. When there hasn't necessarily been a methodology required by the contract, that's actually a scope of work that we've tagged in on occasionally, where it's a change request, and the contractor is doing, here's all the workup and all the backup to prove up how much it cost me extra and what the delay is. We don't necessarily get involved to do the details of it, but I've been requested by, you know, the attorney that's working closely with their project team to add in essentially a memo from your expert on the methodology that was used, and it being, you know, a great methodology, or having, you know, these certain drawbacks, but it was addressed in this way or that way in their assessment. And I just think then you've given, you know, the owner as full a picture as you can of, you know, how you've approached the quantification of that change real time.
Good. So let's move to the third phase, the dispute resolution phase. And then I will pass the floor to Shona. Shona, please. And if you want to complement your previous answer after having heard Laura and Marcela, please also do that.
Thank you. Thanks very much. Yes, I just had a couple of points on this execution phase. One is that I saw someone had mentioned in the chat whether this single source of records is something which might be achieved through BIM. And I think BIM certainly can provide that to some extent. And what we're starting to see now is more and more technology-driven solutions to having that single source of records. So having really real-time data about progress, about productivity. And I think, you know, going forward, I think we'll see a lot more technological solutions to some of these issues. And I think then the issue might be too much data and how to use that rather than too little, but it might solve this issue of having a single source of data, which Marcela was talking about. And then the second point, again, on execution is a point Marcela made again, that contracts don't drive behaviours. And I think that's such an important point. The standard form contracts I deal with have these mechanisms built in that we've been discussing. They build in early warning, they build in risk registers, they build in a procedure to deal with compensation events and claims as the project progresses, for updating programmes regularly. All of that is provided for in the contracts. But what I often see in the contracts which end up in dispute is these have been dealt with in a box ticking manner. So the claims have been dealt with by rejecting them. The programmes have been updated but not accepted, or they haven't been updated at all. And so, you know, you can have the best contract with all of these measures built in, but unless the parties work together to properly operate the contract in the way that's intended, then no contract is going to solve the problems. And this is why I keep coming back to behaviours in relationships being such an important factor. And that probably does lead us quite neatly into the dispute phase. And I guess just to kind of introduce that, again, we're all familiar with disputes. They're expensive to deal with, but not just cost. They're a drain on management time and management resource, when really they could be working on things which will progress the business rather than resolving disputes. Lengthy dispute resolution can mean that businesses take their eye off the ball for normal business as usual activities. And while the dispute's underway, the relationships are damaged and cash flow suffers. So I had two themes here rather than my usual three, but one is to do with the contractual dispute resolution mechanisms. Dispute resolution clauses are the poor relation of all the clauses in the contract. They're the ones that nobody wants to talk about, because when people are entering into contracts, nobody envisages that they're going to end up in dispute. So they're the clauses that no one wants to negotiate and discuss. And when a dispute actually arises, quite often we find that the clause is not really fit for purpose. It doesn't deal well with the situation which has arisen. And so I think it's important when drafting a dispute clause to just test them in potential dispute scenarios and work out what is going to be a good method to resolve the dispute. We see a lot of escalating dispute clauses with different layers. It goes to senior management, potentially to mediation, potentially to a dispute board or to an adjudication. In the UK, we have mandatory adjudication built into contracts. It's a 28-day process from start to finish, from referring a dispute to getting a decision. But one thing, I think it's a good idea, the escalating dispute clause, but what I see going wrong with these clauses is if they're overly complex and overly prescriptive about how the dispute's to be handled. And what that can lead to is satellite disputes about whether the dispute process has been properly operated, which, you know, costs money, takes time, and doesn't get to the heart of the issue. Great for lawyers to battle out whether everybody's followed through all the steps required, but not good for the parties trying to resolve their dispute. So I think thinking upfront about the dispute resolution provisions and what's suitable in each case is really important. And then I guess looking at contract mechanisms to avoid disputes. And in the UK, I mentioned that we have compulsory adjudicate. It's not compulsory to adjudicate, but it's compulsory to have the option of adjudication within the contract. But there are also compulsory payment provisions setting out, so there's a requirement to set out an adequate mechanism for payment within the contract, with the view of being clear about what money is to flow and when, and to provide for interim payments. So I guess the theme here is around building in mechanisms into the contract which deal with the common issues which we know arise and which cause problems in construction contracts. So yeah, that's probably enough from me. We'll let Laura and Marcela have some comments.
Thank you. Thank you. So Marcela, please.
Yes. Well, what I really want to point out in this phase is that for me it's very clear that, again, adversarial attitude when it comes to solve disputes, it's not the solution. I mean, it's not cheap, it's slow, and the worst thing of all is that the solution that sometimes brings is not, it doesn't really make happy. None of the parties can end being very, very satisfied. So having said that, again, we need to look to broaden up the types of mechanisms to solve disputes. Okay, so that's the first statement. And then I agree 100% with what Shona said in terms of be careful with lawyers, because lawyers sometimes make things very complex. The reality is already very complicated, and then the lawyers come and they just draft huge clauses with lots of requirements, and then when you put that to serve to the project, people in the project, it's like, it's a mess, you know, it's terrible. So again, we need, and this is a very important thing I want to say, is lawyers, when you as a contractor or as an owner work with lawyers, try to get some lawyers that are really specialized, because construction lawyers, they really understand, they should understand the impact that a certain clause is going to bring to the project or not. If you hired a lawyer that is like, you know, very good in construction, but also in some other fields, he's probably going to be at her or at his desk, not very aware about the consequences of creating these terrible, complex and intricate clauses. You know, sometimes you find yourself getting like surviving and trying to, struggling with the clause itself and having a dispute about the clause. And that's what really, so creating the mechanism, the whole mechanism, even if it's an escalation process, needs to be simple, very easy to understand, and very easy to apply. So, but I still think that the conflict itself is something that it's going to happen, and it's normal, it's natural. As it's natural to have changes, it's a natural thing to have conflicts. Humans, it's part of being a human and having relationships. So from there, we know we're going to have conflicts, so maybe give ourselves some early opportunities to solve those conflicts when they are still, like they just been born. Not when they go very big and, you know, we have a huge snowball and we don't know how to approach them. So the key would be incorporating more adequate mechanisms. There are mechanisms that allow the parties to dialogue, to have good conversations, to improve the communication, to say things that sometimes it's not really big thing, but it really affected me. For example, mediation. You know, mediation in Latin America, it still has lot to develop and to grow when it comes to commercial relationships and even in construction. And also obviously dispute board. But when it comes to dispute board, I would say that I'm a strong believer that dispute boards needs to be standing dispute boards. I don't really believe much in ad hoc dispute boards, because if you're going to set an ad hoc dispute boards, those dispute boards that you have to establish once the dispute has arisen, no, you know what, you better go to arbitration, because it's going to have it's not really powerful. This is my personal point of view, you know. So if you have a dispute board that help the parties with the execution phase, and then it filtered some disputes, those that you really didn't need to have them, you will have the real disputes, not 20, not 10, 2 of them, the big ones, the real important technical, contractual, and then solve it and make it compulsory, because at least in Latin America, if it's not compulsory, people are not going to even respect what the dispute board said. So it's important, you know. I know in the US there is a lot of experience with dispute boards issuing recommendation, and they work. But at least in Chile, I think it's more about standing board, dispute board, and then adjudication dispute board, because we need to feel that what the dispute board said, issued and said, it's really compulsory, because otherwise the parties, it's just waste of time. So incorporating new mechanisms, giving the parties early opportunities to speak about them when they are new and young disputes, I mean very little ones, and then filtering and discriminating the real important disputes from the other ones that you can solve as a normal thing. Learning to speak, learning to have conversations, difficult conversations, being transparent, and as Shona said, you know, learning to communicate. Because I think in construction industry we have a big issue about having those skills. These are skills, and in my opinion, they are not soft at all. They're very hard, you know. So I think dispute board can really help with that, and also if you have a dispute that it was solved by the dispute board, then when you go to arbitration, that arbitration process is going to be better, in my opinion, because you're going to save a lot of time, and you're going to have more integrated pieces of information that are going to help the arbitrator and even the expert witness with doing their job.
I would like to add, before we have only 5 to 6 minutes, but I'd like to add that your points saying that dispute board, at least if does not solve disputes, a standing dispute board, but at least if it's enough to preserve the evidence, to preserve the truth, not the evidence, because the evidence go in each direction, but the truth, it will be extremely important for the arbitral tribunal, including if the arbitral tribunal can, it occurred to me right now, can listen to as witnesses to dispute board members. And Laura, please, your turn.
Sure, recognizing we're a little bit running out of time, but I had a couple of comments just in my experience with dispute resolution boards. And I shared this with you, the team yesterday. I'm currently on 2 matters where things have gone all the way through the DRB process. and there's been a decision handed down that there was a delay, and then from a contract administration standpoint, there was no adjustment ever made to the schedule between the parties. And so, you know, as we're thinking about language that's going to go into the contract, if there's some way to, you know, ensure that that DRB decision loops back to the project level, I think I've certainly personally seen that missing. As it relates to the general dispute stage, I'll keep it brief. I agree with Marcela. I don't know that we'll ever be in a place where change doesn't happen and there's not some sort of scenario that disputes don't come up in. But I will kind of echo one of our comments from the beginning of the project phase, the planning stage, where as things are clearly headed towards a dispute, I think it's just as important at that stage that the parties develop their realistic expectations of what's going to happen with that dispute. And that's something that I've seen some of our clients do well in, you know, certainly there's a change process that's occurring during the project, but then, okay, now there's a formal claim filed. They're pulling us in early in that process to make sure that they understand, even before a formal claim is filed, sometimes we're going back through and saying, what's the real viability to, you know, a claim of, you know, $26 million versus $14 million. I mean, it matters for what, you know, they're pursuing. And we're coming in at that stage to reset expectations for the, you know, our client that's in a dispute situation. And so I think that early involvement of the expert can really help in informed negotiations, which obviously help in leading to earlier resolution, perhaps avoiding the arbitration at the end of the day. You know, if you're doing that from an informed basis, I think that gives the parties a better chance to really make a better decision for their business. So, yeah.
No, Laura, I think I agree totally with you. And I think it helps whenever I have a case as lawyer, I engage. If the expert was not engaged during the execution phase, I engage on day 0+, you know. Right. I cannot, I don't have claim, I don't have the relief soughts. I only prepare them with the aids of the experts. It's mandatory, should be in a way. Yeah. So very briefly, it was a huge pleasure to have you all. I learned a lot. I will give a 30 seconds for each of you for your final comments. Shona.
Thank you. I can probably be quicker than that, but I think on the theme of disputes, this idea of having early opportunities to identify disputes as they're starting to arise, to manage them and then to resolve them quickly, I think is really important. So yeah, I'll probably leave it there, and thank you very much for having me on this panel.
Thank you. Marcela.
Thank you, Adriana, and thank you, everybody. I learned a lot, not just in this session, but also in the preparation one, so it's great. I'm paid. And I just wanted to say something that maybe we comment, but we didn't have opportunity to say. I think construction industry need to integrate different people. It's very important to integrate women, young people, and people with different perspectives, because as the reality is very complex, we need diversity in order to approach problems from a different point of view. I think we're going to create great synergy if we invite more women and more young people to be part of the team. So we're going to have better communication skills, lots of soft, not really soft, but skills integrated in the teams. Just that. And thank you very much.
And Laura.
Sure. As far as mitigating risk, I think it is mostly, certainly collaboration and relationship have a big deal in that arena. But I think what stands out to me most is awareness. You know, awareness of, as decisions are being made, how is that contributing to risk? And then, you know, as we work with our clients, it's awareness of what will be ultimately required to prove the impact the delay and additional costs at the end of the day, and operating with that awareness in mind throughout, you know, from planning to execution and in that final dispute stage.
Thank you. Thank you. It was, I'm receiving feedbacks from the audience. It was an amazing panel, truly. It was an honor to sit as a moderator. So Victor, back to you.
Obrigado, Adriana. Parabéns pelo painel, foi realmente incrível. Thank you, Laura. Thank you, Marcela and Shona. It was a pleasure to hear your teaching on this relevant subject for us. And it was a pleasure to really have this panel formed only by female attorneys and experts. And we hope, looking forward for the next event, to be in person and to have you all there again to teach us in person. Thank you very much. Obrigado a todos. E com isso, eu gostaria de novamente agradecer a todos que participaram do evento. Acho que o evento foi excelente esse ano, com grandes apresentações, e esperamos que no próximo ano realmente nós possamos fazer esse evento de forma presencial, né, e contando com a presença de todos vocês, e reforçando, enfim, que todos que ainda não são associados do IBDiC, que vocês se juntem ao Instituto. É muito importante a gente ter a colaboração de todos, a participação de todos da indústria, e é importante lembrar que a gente agora, nessa nova gestão, vai constituir novos comitês, e gostaria de ter a participação aí dos membros nesses comitês. Vai ser muito importante que vocês participem diretamente. Eu agradeço a todos e muito obrigado, boa tarde, e a gente se vê o ano que vem. Um abraço.